to the State and Local Legal Center. And Lisa Soronen, who joins us here today, is the head Zoogie over there. And she has been there now for several years. She is not inexperienced in her job. And she is joined today as well by Marcus Green. Following Lisa and Marcus, we'll also have an opportunity to hear from Elizabeth Wydra and Erin Murphy on their trends and observations about the Roberts Court. I want to talk just briefly about the SLLC, the State and Local Legal Center. It is a creation of state and local government communities. It regularly files amicus or amicus, depending on which law school you went to, in support of state and local governments in the U.S. Supreme Court. It also helps to conduct moot courts for attorneys in preparation of arguing their case before the court. It provides for other assistance to state and local governments as they are involved in litigation, especially litigation likely to end up in the Supreme Court. So far, the SLLC has filed over 300 briefs in just slightly more than 30 years. It is a product of and is supported by the Big Seven. Now, who are the Big Seven? Well, most of you know, but let's have a little refresher. It is the Council of State Governments. It is the International City-County Management Association. It is NGA, the National Governors Association, National Association of Counties, NCSL, the National League of Cities, and the United States Conference of Mayors. It is not the Parking Lot Attendant Association. Okay, I'm sorry. I know I was trained long ago to keep sarcasm there and not here. Some of the groups in the Big Seven, in deciding whether to participate in the submission of a brief, those decisions are staff-driven. That is not CSG's approach. And to my knowledge, at least as long as I have been affiliated with it, that has never been the case. Instead, we have a legal task force, and it consists of 12 members, 3 from each of the 4 regions. The regions select the members to that legal task force. The chair of that task force is selected from the 12 and by the national chair. About 8 of the 12 do have JDs, and if we agree as a majority to participate in it, then CSG gives its green light to participate in the brief. Now, very candidly, like SSL, where sometimes I'm asked to include an act in the book that I would not vote for in my own state legislature, we ask the members of that task force to check their politics at the door the best that they can, and look at the issue from a federalism perspective. Is this an issue that we believe collectively is important enough to our states and the like that we should engage? In my experience, most of the time we have hit that target. Occasionally, however, our own individual dreams of a decision have impacted a vote or two, at least speaking for me. As the chair, and I have been honored to serve as the chair, It's been my pleasure to work with Lisa and the SLLC on several briefs over the last many years. This is our most recent work product. This is an important decision. It's an appeal out of the Fourth Circuit, and it tests or it asks the court to reconsider the Palmer Doctrine, which is the immunity that is given to states and political subdivision for Sherman antitrust violations. The effect of it is, in the event that the court were inclined to follow Fourth Circuit reasoning, it could have a substantial impact on how your boards and commissions function, especially when you are appointing boards and commissions, or governors are appointing to those boards and commissions individuals who come from that industry. It's an important decision, and we are hopeful that the court will hold to the standards that it has historically done. Lisa Soronen is the executive director, as I indicated, of the SLLC, and in this role she solicits and firms and attorneys to do this legal work, and it is pro bono. And so she is as much a salesperson as she is a lawyer and an advocate. And she, I understand, has her cell phone number blocked by most law firms in the Eastern Coast states. But she works to secure their services. She organizes the moot courts for the attorneys. And of course, she works with the Big Seven. Prior to joining the SLLC, she worked for the National School Boards Association, the Wisconsin Association of School Boards. She clerked for the Wisconsin Court of Appeals. She earned her JD at the University of Wisconsin Law School. She was unable to get into the University of Idaho College of Law. Joining her as well will be Marcus Green, who brought me his professionally prepared bio this morning. I look forward to hearing from him as well. He is a rising third-year law student at Washington and Lee. He is an intern with us at the SLLC at the time, but is excited to report that he will be beginning an intern as well at CSG in July at the Justice Center. And we are very proud of the work as well that is going on, not just at the SLLC, but also the Justice Center. He has a deep-seated desire to make a career in helping people. And he is an Eagle Scout. I'm an Eagle Scout. Are there other Eagle Scouts in the room? Really? What happened to the rest of you? How many Life Scouts? How many? Okay, well, you got started at least. I give you credit for that. But he is an Eagle Scout, and he is a frequent leader on habitat and other community service trips. He thinks that he is well-traveled in that he is pleased to report he has been to all 50 states. And he brings the knowledge and enthusiasm to the topic today. Please join me in welcoming Lisa and Marcus.
Well, I have to say, I have been speaking at Big Seven events now for a couple of years, and I've never had an introduction even close to that Nor have I ever been as jealous of the introduction of my colleague who has done all these wonderful things. Although I have to say, I got the Gold Award for Girl Scouts, which doesn't have the esteem of the Boy Scout Award, but I just wanted to mention that too. The other thing I have to say is this. So my husband is a consultant and I'm a lawyer, which makes us sort of like this stereotypical DC couple. So consulting, also known as conslutting, but I didn't say that, is white-collar sales. And actually, as Bart points out, my job is also white-collar sales, with my white collar on today. And I want to say this too, the dental brief that he mentioned, actually the named attorney on there is Seth Waxman, who is a former Solicitor General. So Bart jokes about my cell phone being blocked, but somehow I managed to get a hold of Seth, which I was pretty proud of. So I'm going to talk a bit about the Supreme Court's term. And I'm going to skip my initial talk about the SLC because Bart did such a brilliant job of explaining it. So I'm going to begin by talking a little bit about statistics from this term. Not being much of a math person, though I did finish calculus in high school, which I like to brag about, but I haven't done any math since then, is SCOTUS Blog actually does all the statistics on the court, and so I'm going to talk about those. And these are as of June 18th. So we expect 73 decisions from this term, which is about standard for the last couple of years. The court has accepted the highest number of cases from the Ninth Circuit and the Sixth Circuit. Again, that's pretty much to be expected. If you have a case below that was accepted and you won, that's actually really bad news. You have a 75% chance of having your case reversed, and that's, again, about average over the years. So 64% of the court's decisions are 9-0. Most people have no idea of that. Why that's the case is because you only hear about the blockbusters in the news. The bankruptcy cases, the patent cases, the cases that are even more dull than those, you don't hear about in the news. So 14% are 5-4. My guess is that number is going to go up after the other decisions from this when the end of the term are decided. But even that number I don't think is so low. Now, if I asked you and you didn't look on the screen, what justice votes in the majority the most often? The pop culture answer is the right answer, Justice Kennedy. And the justices who agree the most, again, probably no surprise here, Justice Scalia and Justice Thomas, although the ladies tend to vote together too quite frequently, has probably more to do with them being liberal than them being female. But there might be some disagreement on that. So as Bart pointed out, there are a ton of cases this term affecting the states. Just an extraordinary number, to be honest. As someone who summarizes them and writes about them and blogs about them, I'm overwhelmed by them. It's normally the case that there's more local government cases. There were a bunch of local government cases that got kicked off the court's docket for a variety of reasons, and that partially explains what happens here. But there's a ton of state cases. I'm going to talk about a number of them, as will Marcus. The biggest case, I think probably inarguably that's been decided so far is the Schuette versus BAM, which is by any means necessary, kind of an auspicious name. This case involved affirmative action. It made the news. Even if you're not much of a Supreme Court junkie, you heard about this case. So what happened is basically by ballot measure, Michigan voters banned affirmative action. So we all know it's constitutional to have affirmative action. So the question in this case then, is it constitutional to not have affirmative action? And the court said yes, 6-3. Now, the law in this case is a little bit tricky. There's a doctrine that's called the political process doctrine. It evolved out of a couple of cases that came out of the civil rights era. And basically the idea is this. If you have a law that has a racial focus and it makes it more difficult for minorities to achieve their goals, that law has to be reviewed by strict scrutiny. That's how the doctrine goes. And so in this context, Michigan voters said, look, as a result of this voter initiative, we now can't have affirmative action at Michigan universities except if we go through a constitutional amendment. You want to make any other change in front of Michigan universities, you don't like the legacy plan at the University of Michigan or one of the other schools, you can just complain to a variety of people, but you don't have to get a constitutional amendment to change things. Well, Justice Kennedy, writing for the majority, said, we're not going to apply this political process doctrine in this case. And Justice Kennedy said there's basically a lot of problems with this doctrine. First, it assumes that people of the same race think alike. It's hard to characterize people in this day and age by race, which is true. And it's hard to know what people agree on or what people of the same race agree on in terms of policies. The other thing, and I think this is more of the bigger point, is the court said basically this is the bottom line. Racial groups could say they have an interest in anything, and then you couldn't have a voter initiative on that if they claimed they had an interest in it. So that's why the court basically threw it out. But I think there's a bigger reason. Like I said, it was Justice Kennedy who wrote the opinion, and he comes, as you know, from California, where it's all voter initiatives all the time. And he basically said, look, voter initiatives are part of our democracy. Now, it's not uncommon for a Supreme Court opinion to have that one line that sort of summarizes it all, that tells the whole story. And for someone who has to write about these opinions in a very short amount of time, that's the thing that a blogger like me looks for. And this is a line. The court said this isn't about how, this isn't about how this debate is resolved. It's about who resolves it. And we just don't see that the Constitution can prevent the voters of Michigan from banning affirmative action. And that was kind of the court's bottom line. So 8 states ban affirmative action. And I have them on the screen. Some have done this by referendum, some by state law, some by executive order. And interestingly, it's only Nebraska that bans affirmative action at the university level. The other states ban it through public contracting, public employment. Presumably, all these bans are unconstitutional. Justice Kennedy said about as much in his opinion. I guess it's a plurality opinion, technically. And one of his rationales for upholding the ban was to say that, California, for 15 years, has had precedent that says they can ban affirmative action in public contracting, public universities, public employment. One thing that's been very interesting to me about this case is that the public employment and public contracting angle has received very little attention. If you saw how the media handled this case, they handled it as a public university case, which is the context it came up in and what was challenged in the case, but it has bigger implications. I wonder why this has been the case, why people haven't talked more about the bigger implications. It may be that in public contracting and in public employment, that affirmative action isn't as frequent as it is at the university level. It's certainly not as controversial. But I don't know. So in terms of like the bigger picture on this case, from all the reading that I did on this case at that time, and there was a ton to read, no commentator, no one predicted that the course would go the other way. This was considered a slam dunk victory, or it was predicted to be a slam dunk victory for the voters of Michigan. But I believe this. Had the court wanted to go out the other way, it could have read the political process doctrine more generously. It could have adopted it, so to speak. It didn't, but I think it could have. So interestingly in this case, again, I do like to include pop culture because sometimes this stuff can get a little esoteric. Justice Sotomayor's dissent got as much attention as the Chief Justice's opinion. So the plurality decision in this case was 20 pages long, about 20 pages. The Chief Justice's opinion was 2 pages long. Justice Sotomayor's dissent was no less than 60 pages. And she said basically, if we want to stop discriminating on the basis of race in this country, we've got to have frank conversations of race. Justice Roberts wrote back and basically said, it's my opinion that racial preferences may do more harm than good. And look, I am talking about race. I'm just not saying what you want to hear. And I thought it was interesting because the debate felt more personal than most Supreme Court opinions get. And the debate that they're having between them is one that you could hear at a bar, somewhere in Middle America. I mean, it's a very simple, sort of classic debate. Is affirmative action a good idea? And in theory, the court isn't resolving that, and they say they're not. But on the other hand, like a discussion about it is inevitable. It simply can't be avoided. So the other thing I'll say about this case is that there's a lot of speculation. I don't know if Erin's going to talk about this at all, and Elizabeth when they talk about the Roberts Court. And I'm trying to avoid talking about the Roberts Court in the big picture. But there's a lot of speculation about whether the Roberts Court is chipping away at the use of race And I think the short answer to that is yes. If you look at the last couple of terms, just the last 2 terms, in fact, it's actually Section 5 of the Voting Rights Act being nullified. The Fisher case was an affirmative action case out of Texas. It wasn't a huge case, but as someone who in my former life followed the public university cases very closely, this case just made it more tricky and harder to have an affirmative action plan at the college level. And then you see Schuette sort of, doing the same thing. But I think characterizing this as like the Roberts Court, which then kind of pulls you back to John Roberts, is unfair and probably inaccurate. And my thoughts are this, that when you look at the future, like let's look at the next 10 years, I think what happens with race will be more decided by the 3 justices that we get to replace the justices that are 80 or above than John Roberts himself or the justices who are currently on the court. My point is just to say that the court's relationship to race may change over time. I don't know how it will change. Time will only tell on that. But I don't think we have all the answers, I guess is what I'm trying to say. So the second big case of the term that's been decided, at least, I think without a doubt, is Town of Greece versus Galloway. This could have been a huge case for state legislatures. It was not. It's a legislative prayer case. The court hadn't heard such a case in 30 years, and it really didn't change the landscape much for state legislatures. It maybe clarified some things about sectarian prayer, but other than that, it didn't do very much. So I'll tell you a little bit about the case. Basically, in the town of Greece, it's a town outside of Rochester, I think, in upstate New York. It was all Christian prayers all the time. For about a 10-year period, the town of Greece, it wasn't a phone book, but it was like a phone book. They called all the houses of worship, essentially, and invited their priests, ministers, whatever, to be a chaplain of the month. And it just so happened that everyone in the town's borders were Christian. Now, had they gone and grabbed the Greater Rochester phone book, it would have been a whole other thing. But just in this little town's borders, it was all Christian prayer givers. So what happened basically is they ultimately had some of their more diverse prayer givers, but it is after sort of a 10-year period. And so they were sued, and the lower court basically said they could not have a practice that had so many Christian prayers. So the speculation as to why the court took the case ran high. It wasn't totally clear. The Second Circuit basically said, after our decision, it's going to be hard to have prayer at all. We have made things so difficult in our decision that we think prayer is basically going to go away. And they said that sort of unapologetically. Another thing was the concern in the case, and why this case was so interesting, was, like I said, it was the all Christian all the time. And there was speculation the court was going to say prayers have to be non-sectarian. They can't refer to Jesus all the time. It can't be all Christian prayers. The other thing is this case ended up was out of a town context, not a state legislature context. And the idea is that the town context is different. And the reason why it's different is because if you go to a town board meeting, presumably you have business there. You want something, and you would then be subjected to this prayer that you might not want to hear. If you go to hear a state legislature, you have to be invited to speak. You don't just have business before a state legislature. So the idea was, well, maybe the court was going to say something about the different context. The other thing is the court might overturn Marsh. Marsh was this case from 30 years ago where the court basically said, look, legislative prayer is just kind of an exception. It's we've been doing it a long time. You can continue doing it, no problem. The other thing is that there's all these First Amendment tests. You don't want me to go into them, but there's endorsement, there's coercion, there's a Lemon test, there's other tests you can't even imagine. And Justice Connor had liked the endorsement test. She's not on the court anymore, and the court hasn't taken a lot of religion cases. So the idea was maybe that the court would take this opportunity to dump the endorsement test while she was gone and pick up something else. The bottom line is no one knew why the court took this case. And in the end, the court upheld the practice 5-4. And the most helpful thing for state legislatures that came out of this case, I think, is this. So in the Marsh case, the minister was hired by the state legislature, and he had all these Christian prayers. So what happened was a Jewish legislator said, hey, I'm tired of your Christian prayers. And he took out Jesus, he took out some of those references. And one way to read Marsh was to say that prayers had to be sectarian, because the minister in this case had taken out all these references to Jesus. And the court was very clear that this minister just took them out to be sort of more appealing to his audience, and that you don't have to have non-sectarian prayers. That's probably one of the biggest things that came out of the case. The court said it's hard to come up with these generic prayers. Like, no one really knows what a non-sectarian prayer is. And the court said it's okay to do all Christian all the time as long as you invite people from the community on a non-discriminatory basis and you make an effort to include other religions. And remember I mentioned how one argument was, well, in the legislative context, in the town context, it's different than the state legislative context. Basically, Justice Kennedy said, look, you're all adults. If you go and you hear a prayer at a town meeting and you don't like it, his words are, it offends you, excludes you, disrespects you, deal with it. And, that wasn't so well received by the dissent, but, that's what he said. But he also said, too, look, it's not like towns can look and see who isn't praying and then not, give them a variance or a permit or something on that basis. Not surprising, this case had a vigorous dissent written by Justice Kagan. Her bottom line was all Christian all the time is not okay. And she said, when citizens encounter their government, they should encounter it not in terms of their religion. And I thought she had a very powerful thing in her opinion where she said, imagine yourself as an immigrant at a naturalization ceremony, and she read one of these prayers before the town of Greece. And, they're these over-the-top, Jesus, very religious prayers. And, it was kind of sobering to read it, I have to say. So some practical advice for you state legislatures. If you get a chaplain of the month, my advice to you is this. You should invite, on a non-discriminatory basis, all the chaplains, at least in the city limits of the capital you meet in. And I was thinking about, I always want to say Pierre, but it's Pierre, South Dakota. You may not be able to get a diverse group of chaplains in Pierre, South Dakota, but give it your best shot. And then if I did a webinar on this, and I was fascinated to learn that in the town context, it is town board members who do these prayers. And, a town board could have all Christian prayer givers, even in a very diverse community. And I think that, again, if it's state legislators who do these prayers, you want to make sure everyone's invited. And I think if someone does go overboard, you can tell them, look, you can't go overboard anymore. I think the court's opinion makes that sort of clear. So it's an interesting case. I think it's got some practical implications, but it doesn't have maybe as many for state legislatures as it could have. So now on to the environmental cases. There's two actually Clean Air Act cases from this term. They're actually both pretty big cases. One hasn't been decided and one has been decided. I'm going to talk about the one that has been decided. It's EPA versus EME, Homer City Generation. So this case involves the swirling of upwind and downwind pollution. Apparently this is all news to me. Pollution travels not just from upwind states to downwind states, but sort of all around. And since the 1960s, the EPA has been trying to solve this problem, or at least assign responsibility for it, which isn't all that easy. So currently, the Clean Air Act says that it prohibits any stationary source within a state from emitting any air pollutants in amounts, and this is the key thing, which will prevent the attainment or maintenance of air quality standards in other amounts. So the bottom line in this case is that EPA figured out how to reduce pollution on a cost-effectiveness basis. So again, like I said, my calculus in high school is not helping me to explain all of this. The best I can really say about it is this. The EPA apparently will come up with like a dollar amount and figure out how much they can reduce pollution based on that dollar amount. Then they'll come up with like a higher dollar amount, and they'll determine, does it reduce pollution enough to make it sort of worthwhile? And if it doesn't, they'll go with a lower dollar amount. So the bottom line is the upwind states were saying this is a cost-effectiveness business doesn't work for us. We think it should be done on a proportional basis. But the court said, look, the statute uses the word amount. What does amount mean? It could mean proportional, per capita. And they said that proportional doesn't really work if states are polluting multiple states. And Justice Ginsburg's opinion has a very complicated math formula to explain all that. I just sort of glossed over it because I figured no one would ever ask me to explain it. So Bart, please don't ask me a question about that because I can't really explain it. But the bigger thing maybe in terms of federalism is there's a question in the case about who's going to be solving these air pollution problems. And basically, states are supposed to get the first crack at solving the problem. But if they do a bad job and the federal government comes in and says, you're going to solve the problem this way. And the state said, here's the thing. We're supposed to get these air pollution budgets, and we don't get them until after we have to come up with our state plan. So then we can't come up with the best state plan, and we end up then having to have the federal government step in. And Justice Ginsburg basically said, yeah, I agree that might be unfair, maybe it's not unfair, but, the statute's very clear that this can be done. So if you guess wrong, you're out of luck. So again, this case got more attention for its dissent than for what actually happened in the case. But first I should mention that this case was considered a rare win for EPA. That's how it was covered. But now back to the pop culture interest in the case. So this is what happened in the case, and I'm very sympathetic of Justice Scalia, someone who's more a big picture person and can be known to make some mistakes on the details. So in his dissent, he basically said, the whole debate in this case was about cost effectiveness, and he basically said, there was the previous case where EPA tried to argue cost effectiveness, and they basically got it all wrong, and that was bad. And it turns out actually that it was the other side that was arguing cost effectiveness. And so you see all these unflattering pictures of Justice Scalia and his face posted everywhere. Look at the mistake he made, blah, 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 blah. The long and the short of it is the opinion was corrected within a day, and probably he isn't any worse for the wear. But it did, like I say, result in a good deal of controversy and, got some media attention. So I am running out of time because I want to give Marcus his due, and he's got some good cases. But I am going to talk about the Brandt case, if for no other reason than my nanny asked me, do you get invested in these cases? Well, that's not the word she used, but she asked me, do you care how these cases turn out? I said, to be honest with you, not really. I said, here's the thing. I said, I have my job to do. I give it my best shot, and when I'm done with it, I'm done with it. How they turn out, look, I can't influence these justices any more than the brief. But then, then that's not true. Then the case comes out, and I'm so mad. And this was the case that broke my heart. It was Brandt versus the United States, and that's why I have to talk about it, even if it involves going into Marcus's time. So it's kind of an obscure way. It's also a case that affects more states out west, and Bart's here, so I feel like I got to bring it up. But so this case, it's kind of a very obscure case, and I think it also illustrates the intrigue of the state and local legal center. One day I'm working in qualified immunity. One day I'm working on railroad stuff. And the other thing, too, I just have to mention this, is that the case that caused a circuit split in this case came out of a place called Bayfield County. This is the most northern county in Wisconsin. So my mom grew up in Bayfield County. So I read that case, and I randomly called this guy who was on an amicus brief and was like, what in the world is going on in this case? I've read all the briefs. I can't make an ounce of sense of this. He ended up writing our brief. And there are literally 5 people in the United States that know this issue, and now I call myself the 6th. I mean, it's so obscure and so weird. But that's why I got to tell you about it. I was absolutely heartbroken when it was an 8-1 decision against our position, but not really surprised for the reason I'll explain to you. So here's the deal. In the 1800s, the United States wanted to expand west, and there was no really easy way to do it. So what they ended up doing was giving railroads a bunch of free land. Then people got mad. They were like, why are the railroads getting the free land? And so the United States stopped doing that. It gave rights of way over land and kept the land and then got rid of the land later. So the issue is whether in one of these land grants, or these, I'm sorry, not land grants, right-of-way grants from 1875, whether or not the United States retained all these years later a right of reverter in that land, or the railroad right of way, or whether it was a mere easement that went to the property owner who ultimately ended up owning the land. So we filed an amicus brief in this case, and you might wonder why, because this is a dispute between the federal government and a private landowner. Well, like I said, the case that I was talking about was a dispute between Bayfield County and a private landowner, and this is sort of why. There's a statute from 1922 that basically says that state and local government get these rights of way if the United States has an interest in them. Well, the Supreme Court said the United States doesn't have any interest in them, so the statutes kind of went away. But it appeared that these sort of went automatically to state and local government. So now, why was this case a loss? And this is, again, remember how I told you sometimes every case has that quote that sort of defines the case? This quote was like being kicked in the stomach, but it was a kick in the stomach I knew I was going to get. The government loses the argument today in large part because it won it when it argued the opposite more than 70 years ago in the case of Great Northern Railroad versus the United States. This is a perfect case that illustrates the problem of being short-sighted. So basically, 70 years ago, there was a railroad that discovered oil underneath the right-of-way. So it wanted to say, because it owned the land, or the United States still owned the land, that let me back up. The United States wanted to say that it had just merely given an easement to this railroad because the United States still owned the underlying land. And basically the court bought that argument. And so if it only gave an easement 70 years ago, it only gave an easement, 150 years ago, or how many years ago it was in 1875 when they did this. And there was an argument, and it was very much explored in law review articles, that the United States got it wrong 70 years ago, and that they totally misunderstood the law, and this had been very well developed in the last couple of years. The court just basically ignored that, except for poor Justice Sotomayor. And like I said, there were all these statutes that sort of said, if the federal government has the land, then it goes to state and local government. And the court basically said, these statutes talk about how the land can be disposed of if the United States owns it. Doesn't own it. Didn't know that 70 years ago, doesn't own it now. So like I said, it was kind of a heartbreaking loss. So with that, I'm going to turn my presentation over to Marcus. He's going to talk about a couple of other cases involving states that have been decided. And for the person running the PowerPoint, this is going to involve a mad dash through the PowerPoint to slide 51. Marcus, it's all yours.
Thank you, Lisa. Bart. Apologies for one moment. So I'm going to go ahead and I'll be talking about 3 cases in particular today. The first of which, I know that Lisa had mentioned her lack of willingness to go bring you all back to high school calculus, but if you'll bear with me for one moment, we're going to go back to high school statistics. Specifically in this case, we're talking about mental handicap and the death penalty. Before you, of course, is a standard bell curve, and you're looking at distribution of IQs. In this case, what you want to pay particular attention to are IQs at or below 70. So that's 2.3% of the population. And specifically, that's what we're referring to when we're discussing mental handicap individuals. So the case in which this discussion comes up is Hall versus Florida. The historical context behind the case is a 2002 decision in Atkins versus Virginia, which simply said that the death penalty doesn't make sense because it doesn't serve a penological purpose for individuals suffering from mental incapacity, or at the time what was referred to as a mentally retarded criminal. That's because typically you're thinking of punishments in a criminal context as serving a purpose of teaching someone that what they did was wrong. And that lesson doesn't really stick when the person doesn't have a direct understanding of what it is that they did. However, they did state in that opinion, and this is essential to this case, that they leave it to the states the task of developing appropriate ways to enforce the constitutional restriction upon their execution of sentences. So here's what the states did. 18 states have no death penalty anymore, either because they've been abolished or they've been abolished for strictly new offenses, and they include in this calculation in the majority opinion the state of Oregon, who's only executed 2 individuals in the past 40 years. 23 states decided that being given that information and understanding that an IQ of 70 was considered mental incapacity, developed a range. So they decided that individuals who demonstrated an IQ within a certain frame, typically 70 to 75, were considered to be mentally incompetent and therefore would be ineligible for the death penalty. IQ as a specific number was limited then to 9 states. And those states, as described by the majority opinion, were Florida, essential in this case, Virginia, Kentucky, Alabama, Arizona, Kansas, Delaware, North Carolina, and Washington. Now, the overwhelming majority of those states haven't actually had this issue come before their own court, but need to be aware of the outcome of this decision. The dissent, of course, takes a slightly different approach, interprets 10 states to have hard numbers opposed to 9, and creates more of a range and simply discounts the states that have abolished the death penalty entirely. So the facts of the case specifically, and it's gruesome in all death penalty cases because regardless of the mental capacity of the individual, you're still talking about an action that was punishable in the first place by death. So it was a kidnapping, beating, raping, and murder of a 21-year-old pregnant woman, and subsequently the sheriff. So the case was tried actually before Atkins, that 2002 Virginia case, back in 1981, and at the time there were no other Supreme Court discussions about death penalty with persons who had intellectual disabilities. So Hall had taken multiple IQ tests, and the lowest score he had ever received was a 71. However, in Florida, if you had an IQ above 70, they were considered not mentally retarded and incapable of demonstrating additional evidence at trial. So the Florida decision said Hall is not allowed to show this additional evidence, and it was eventually reversed 5-4, saying that Florida's threshold requirement of a 70 IQ was unconstitutional. The split was among party lines: Ginsburg, Sotomayor, Kagan, Breyer, and Kennedy, which very closely mirrored the Atkins case back from 2002, where Kennedy, Ginsburg, and Breyer were against Scalia and Thomas at that time. Simply put, the decision from the case really doesn't have a rule pertaining to anything other than the limit at an IQ of 70. So as far as states specifically, the court made it a point to say that IQ scores that fall somewhere between 70 and 75 would probably be impermissible under these statutes, but then individual lawyers must be allowed to offer additional clinical evidence for that range. However, there wasn't this sort of discussion for IQ scores described at 75 or greater. So what does this mean for the states? Specifically, Florida, Virginia, and Kentucky all had the exact same wording in their statute, saying that an individual who did not demonstrate an IQ of 70 or below was not permitted to demonstrate additional evidence for their case. This, of course, will now need to be changed. However, the question that we're sort of left with is, what if the IQ was at 75? So in that first chart that was shown, where they had the distribution bell curve, what was described by the medical community at large is the fact that typically IQ scores are looked at as a range. So rather than just a hard number, they typically allow 5 points in either direction for a standard error of measurement. So by having an IQ score limited to be able to demonstrate this information at 75, what you're doing then is accounting for any misgivings in the specific examination. So we're creating a buffer zone to say, okay, although specifically it needs to be below 70, someone with a score of 75, although incredibly unlikely, could in fact have a score below 70 and therefore should be permitted to demonstrate evidence. So the court in their decision really sort of puts into place in the 9 states mentioned before, and specifically in Florida, Virginia, and Kentucky, an immediate need to have that sort of change. The next case I want to discuss with you all is specifically focused on preemption. What's pictured here is the former site of the CTS corporate factory in Asheville, North Carolina. And of course, you all are familiar with the idea of preemption, the idea of what's more important, the federal law or the state law. And more often than not, the federal law will trump the state law. The issue before the court in CTS Corp v. Waldberg dealt specifically with CERCLA or the Superfund. As a show of hands, who's more familiar with CERCLA? And who's more familiar with the term Superfund? Okay, interesting. Well, I'll probably use the two interchangeably for just a moment. So generally, as it seems the overwhelming majority are familiar with both concepts, the idea is to establish a comprehensive response mechanism to shift the costs of cleanup to the parties who were responsible, keyword being responsibility, for any environmental damage done. Now, what's important in this case is the distinction between two very similar terms, the statute of limitations and the statute of repose. The statute of limitations typically says that when someone commits an action to sort of speed up decisions, that you need to strike while the iron is hot. So you want to put in place a deadline that can be extended only by equitable factors, saying that you must bring X claim within X amount of time. The statute of repose is sort of flipped as opposed to the person trying to bring the claim from the perspective of the person who actually committed the offense. So rather than a statute of limitations where you know that you're liable for X amount of time and that in that time you have someone who you can sue for what happened, a statute of repose takes the point of view of the offender and says that after X amount of time you are no longer culpable for the act. And typically that's something that we'd like to see. I mean, you own a home, you move away from the home. At some point in time, you'd like to think that this can be something you no longer have to worry about and consider on a daily basis. So CTS operated an electrical and electronic parts facility manufacturing from 1959 until 1985. In 1987, they sold the land to Wahlberger, a series of 25 property owners who later discovered poisoned drinking water but didn't file the suit until 24 years later. Now, North Carolina has a statute of repose in place saying that liability for these sort of claims must take place within 10 years. And now you're looking at a 24-year gap. However, CERCLA, in an effort to have the party liable pay for the damage done, had a provision that allowed it to overrule statutes of limitations. So the Supreme Court issue was whether or not a statute of limitations could be used interchangeably in this case with a statute of repose. The result here was a reversal of the Fourth Circuit decision saying that a statute of limitations and a statute of repose, in the view of the Supreme Court, were different things, and that CERCLA does not preempt a state statute. Again, a very rare win for state statutes when it comes to these kind of decisions. The idea generally is to prevent surprises, that you don't want to have an organization that's been on the land for X amount of time and has, for all of their knowledge, at this point been released of their liability, have someone come back so many years later and sue them for the damage that may have been done. So generally it's so much for a timely cleanup of hazardous waste sites in the view of the dissent. Not so surprising, the decision when you're considering it, that Kennedy wrote on behalf of the states' rights saying that they have this in place and that language distinction between repose and limitations could have been something that was commented on then, but in fact was not. So how does this affect the states? The statute of repose is present in the context of products liability in 19 different states, and they're listed before you. 2 states specifically have ruled that a statute of repose in the context of products liability are unconstitutional, Arizona and Rhode Island. So sort of the effect that you may be seeing now in state legislatures is whether or not you see increased lobbying efforts on the part of organizations involved in potential products liability suits, and whether or not at this point they'd want to put through additional statute of repose language to be able to sort of create this liability buffer for CERCLA and similar acts. In total, 46 states have statutes of repose applied to real property. However, you're less likely to see a CERCLA or a Superfund issue with those. Another effect to be looking for down the line is in Brandt versus United States, which is an 11th Circuit Federal Tort Claims Act that alleges contaminated drinking water at the Camp Lejeune Marine Corps Base in North Carolina, which is also a CTS site. Here it's poisoned drinking water, and interestingly enough, it sort of creates this perverse incentive to pass statutes of repose in states that want to lure certain types of industry. Similar to how you'd see the corporate structure set up in Delaware, now all of a sudden you can see very forgiving statutes of repose set up among states to lure these potentially chemical hazardous industries to the area, because it does offer this wonderful protection for the organizations themselves. The last case was geared up to be one of the biggest of the term and ultimately kind of fell flat on its face. Very shaken, not stirred, Bond versus United States was a Third Circuit framing the treaty power argument, specifically looking towards the Chemical Weapons Convention. Now, for those of you who are not familiar with Bond, it's straight out of Jerry Springer. You have a lovely woman in Pennsylvania who found out that her dear friend was pregnant and that none other than her own husband was the father. Rather than wait for a spot on the show, as their casting season is very limited, she decided to take matters into her own hands, spreading a whole bunch of chemicals that I'm not even going to try to pronounce on her friend's mailbox, car door handles, and house doorknob. The zealous prosecutors decided that in this case, as opposed to just applying traditional state law, they would attempt to apply the Chemical Weapons Convention. Now, the Chemical Weapons Convention, for those of you who aren't as familiar with it, was originally put in place to prevent the gathering and use of chemical weapons in a very warlike context. So you're typically thinking, World War II mustard gas sort of era. It was ratified by the U.S. in 1997, implemented in 1998, and the convention itself states that the purpose for its existence is tracing back to the introduction of mustard gas in 1917. In that same context, you're sort of looking, and this is what the Third Circuit did specifically, at the Migratory Birds Act, dealing with Missouri v. Holland and banning the hunting of certain migratory birds over U.S. states. It dealt really with the treaty power. So Congress has the power to make treaties, as I'm sure you're all aware. But the question then becomes, what is necessary to implement them? The appellate decision in Bonds said that so long as the treaty is valid, states shouldn't have the power to prevent what is necessary to write laws supporting those treaties. As it would happen, those are kind of the arguments that were put forth by Bond, whether or not the statute reached the conduct, and then even if it did, that Congress didn't have the power to enact it. So at that point, you're looking at the necessary and proper clause. You have before the states as a whole the idea of, on the national level, the implementation of a treaty, but then how it becomes enforced at the individual state level, with Congress arguing that they're able to prevent whatever state statutes are in place that would override this international relationship, and the states saying, hold on, wait a second, you don't have the power to enact this as broadly. The result here was a 9-0 reversal, and although it geared up for that key issue regarding whether or not the states on an individual level had their statutes overridden by the necessary and proper clause in implementing treaties, the Supreme Court really just dodged that issue entirely and focused instead on the idea of intent. So after all of this buildup for a massive Chemical Weapons Convention case, they ultimately said simply that the Chemical Weapons Convention doesn't apply to a jealous woman who had her husband impregnate her dear friend. Of note are 3 justices who concurred in the judgment and did deal with the Third Circuit issue that was presented, specifically Scalia, Thomas, and Alito, discussing the fact that the power of convention treaties generally to create domestically enforceable federal law was not a power that was in the hands of the federal government. So what are the state effects in this case? Really not much of anything. Refers to the basic principles of federalism embodied in the Constitution to resolve ambiguity in a federal statute. Simply put, the majority said, well, if we can resolve this in a way that doesn't deal with the really hard question, that's what we're going to do. And that's what they did. They simply said that the Chemical Weapons Convention was not meant to be applied in this context, overshooting the entire issue of treaty implementation entirely, although what the concurring opinion did do is it set up for those sort of arguments to be made down the road.
Thank you. What we're going to do now is allow for a few questions, and then we will go to part 2 of our presentation and hear from those 2 individuals. And then at the end of their presentations, we'll open it up for additional questions, not just for the 2 of them, but for all. So, with that, Who would like to ask the first question? Please. It's the first question that's always the hardest. Thank you for your courage. Go ahead.
It's okay.
Well, we're going to go till 10. Was that your question? All right, go ahead.
Earlier this year, a new, strong painkiller drug was released, and Massachusetts and New Hampshire both took actions at the state level. It was released, the FDA approved it, took action to prohibit the use of that drug in their state. There was show my non-lawyers piece. There was action. The Massachusetts governor banned the sale of the drug in his state. That was not held by the first court. Do you know what's happening with that as to whether states are going to be able to take action like that?
I'm familiar with the issue that you mentioned and the painkiller that you're talking about. I don't know where it's at and whether there'll be other state action, but the drug cases are a perennial topic for litigation, even with the Supreme Court involved in them in a variety of contexts. I think in the last couple of years that I've been at the SLC, there's been at least one drug case every term, so I wouldn't be surprised to see more on it.
Okay, thank you. Additional question, please.
In Ohio, we've struggled with, Cliff Hyde from Ohio. In Ohio, we've struggled with our renewable energy portfolio questions and the constitutionality of in-state standards. And we understand that no court yet has ruled that the in-state standards are unconstitutional. However, there was a dicta that was written somewhere in one of the circuit courts that said that it is, and so a lot of states are now changing how they're looking at the in-state standards. I wondered if you feel that this is going to get to the Supreme Court and if there will be a decision in the near future.
Well, it sounds like if all you have right now is dicta in a circuit court ruling, it would take a while to, like the Supreme Court mostly takes cases when there's a circuit split. So what you'd have to get for the court to take the case, generally, but not always, is two circuits ruling differently. But to the extent that you've got something, this even if it's just dicta, and dicta is like the Supreme Court or a court sort of extrapolating on something that isn't necessary to the holding of the case. If you've got that and people are relying on it, and you've got other states involved in the issue, it's probably just a matter of time until there's an opinion on the subject and then possibly another one. It sounds like you've got some time to wait on it, but all you need is a couple rulings and a split, and there you go.
Okay. Next question. That's it. Is it too early in the morning? Well, then let's go on. But be prepared to ask additional questions here at the end. Our next two presenters I will introduce at the same time and invite them both to join me here, and then after both of them have spoken, we will open it up again for questions. Let me introduce them. One of our next two presenters is Elizabeth Wydra. She is the Constitutional Accountability Center's Chief Counsel. She frequently participates in Supreme Court litigation, having argued several important cases in federal courts of appeals. She joined CAC from private practice at Quinn, Emanuel, Urquhart, Oliver, and Hedges, San Francisco, where she was an attorney working with former Stanford Law School Dean Kathleen Sullivan in the firm's Supreme Court appellate practice. Previously, Elizabeth was a supervising attorney and teaching fellow at the Georgetown University Law Center Appellate Litigation Clinic, a law clerk for Judge Browning from the Ninth Circuit, and a lawyer at Shaw Pittman, a law firm here in Washington, D.C. She has appeared on several news networks as a legal expert, has been quoted extensively in print media, and is a regular contributor to the ABA's preview on the U.S. Supreme Court cases. She's a graduate of Yale Law School. Additionally, we will hear from Erin Murphy. Erin is a partner at Bancroft, where her practice focuses on Supreme Court, appellate, and constitutional litigation. Ms. Murphy has worked on numerous significant matters in the Supreme Court and successfully argued before the court on, I've lost my place here, I apologize, limits on campaign contributions. She has also argued before the U.S. Court of Appeals on important constitutional questions, including the scope of the recess appointment power and the application of ex post facto clauses on sentencing guidelines, and I put guidelines in quotes. Erin has briefed several high-profile Supreme Court cases, such as the landmark challenge to the Affordable Care Act, Bond versus the United States, and the American Broadcasting Company versus Herrero. She served as a law clerk to Chief Justice John Roberts in the Supreme Court and Judge Diane Sykes of the Court of Appeals for the 11th Circuit. She has, between clerkships, served as a Bristow Fellow in the Office of the Solicitor General, and afterwards she worked in the National Appellate Practice of King and Spalding. She graduated from Georgetown University Law Center. Now, before they come up, many years ago, you only get a few, in the last Monday of March in 1990, I had a little matter before the United States Supreme Court. My co-counsel in that case was a former Solicitor General to Ronald Reagan named Rex Lee. He was at the time with Sidley and Austin, as well as the president at BYU. He was a busy person. It was a very interesting experience for me personally, having spent a lot of years trying cases, but never having been in that forum, to sit in a conference room where I was the only person who had not clerked for a justice of the United States Supreme Court, and to hear them prepare Rex, who at that time had argued, I think, 47 or 48 cases before the Supreme Court, and he himself had clerked for Justice White, who was still on the court at the time, to hear their questions, and having tried the case and having had the matter before the Ninth Circuit, and to hear these former law clerks put texture on not just the question you could anticipate, but the perspective of each justice, was a very interesting experience, especially the following Monday morning when I watched it play out exactly as it was suggested. We are very pleased to have both of you here. Please join us, and we look forward to your presentation, and we look forward to giving you a chance to field a few questions.
Good morning. So I am Erin Murphy, and I'm going to talk to you guys first this morning a little bit about the McCutcheon versus FEC case, which you've probably heard a lot about, some true, some not so true. And this is the case that I did argue on behalf of Mr. McCutcheon and the Republican National Committee. And then I'll talk just a little bit about some observations about the Roberts Court in general as we're reaching 10 years of the Chief Justice's tenure on the bench. So, McCutcheon. is McCutcheon really the end of campaign finance restriction as we know it? I do not think so at all. In my view, McCutcheon is actually really a rather straightforward application of a number of principles that we've seen from the Supreme Court's campaign finance decisions for the past few decades. Now, McCutcheon is, campaign finance is not exactly really a federalism issue, but it's obviously very important for the states because what Congress can't do, generally speaking, the states aren't going to be able to do either, and the particular issue in McCutcheon is relevant to a number of states. I think there's about 10 states that have the kind of restriction that was struck down in McCutcheon. And McCutcheon involved what's known as an aggregate contribution limit. That is a limit on basically total contributions that you can make in an election in general. So what you have are base limits on how much you can contribute to any one candidate, any political party, any PAC. And then on top of that, Congress had put in place this aggregate limits that said, and on top of that, we just don't think anyone should spend more than about $130,000, I forget exactly what the number was, and what that operated to do, specifically as to candidates, which I think was the piece that troubled the court the most, is it basically meant you could give the low base limit maximum to about 9 candidates, and after that you just couldn't contribute to any. And there's perfectly logical reasons that somebody might want to contribute to more than 9 candidates in an election, and might want to contribute the relatively modest base limit of, if you combine a general and primary election, about $5,200. So the court ended up holding the limits unconstitutional in a plurality opinion written by the Chief Justice. Justice Thomas wrote separately to say basically he thinks there shouldn't be any limits on campaign contributions, but 4 justices didn't feel the need to get into that debate here because they viewed the answer to this question as pretty much compelled by existing case law. So what are these principles that the court relied on? I think the first one is a slightly less controversial one. It's the general notion that when the government wants to impose limits on campaign contributions, the only legitimate basis that it can invoke for doing so is to prevent corruption. And most importantly, what that means is you can't impose contribution limits just because you don't think there should be as much money in the system, or because you don't think some people should end up contributing more than others. The concept of you can't impose them to try to equalize the relative ability of individuals to influence the political process. You need to be imposing them to try to target some sort of corruption problem. This is a principle that has existed since Buckley itself. That was the basis upon which the court upheld contribution limits back then, and the court has consistently said that's really the only legitimate basis. Now, where this gets a lot trickier and a lot more controversial is what does corruption mean? And I think if you look at the opinions, the majority and the dissenting opinions here, that's really the crux of the ongoing debate and disagreement among the justices. The majority opinion says here something that it said very clearly a few years back in the Citizens United case. Corruption means quid pro quo corruption. What you can target is conduct that's likely to essentially create a bribery relationship between someone who's giving a contribution and the candidate who's receiving it. What the court said corruption does not mean is spending enough money that politicians are more responsive to you, feel more influenced by you, are more willing to pick up your call, feel more gratitude toward you. The court said, generally speaking, that's actually how the political system's supposed to work. We want politicians to be responsive to the people who take a very strong interest in what they are doing and use every resource at their disposal to encourage their legislative representatives to vote the way they want them to vote. We're really only concerned when the amounts get large enough or the connection is so direct that we are worried that there's a real potential for bribery, or at least a really high potential for the appearance of bribery. This is where the dissenters just completely disagree with the majority and have for a while on this, and they say that's not a fair understanding of corruption. Corruption really needs to encompass something much broader. It's the general notion that the average person is going to look at the system and say, if this person is giving millions of dollars to all these different politicians, what's the point of me giving some money? What's the point of me voting? Because they're really going to have captured the elected officials, and you know, I've lost confidence in the system in general. And the dissenters say Congress and state legislatures need to be able to target this broader conception of, we don't want undue influence in the system, we don't want excessive gratitude toward the wealthy, toward the corporations, whatever it may be. You know, all of that is just as concerning as the narrower concept of quid pro quo corruption that the majority is talking about. Now, this debate really isn't anything new. Quid pro quo corruption is what the court talked about in Buckley, and ever since we've seen this kind of shifting back and forth on the court in one direction or another. I think, you know, the furthest the court's gone in the extreme of the direction that the dissenters in McCutcheon were talking about was probably the McConnell decision about a decade ago that upheld the soft money ban. And there, kind of for the first time, you know, Justice Stevens crafted a majority of the court that really took this broader notion of, yeah, you can target influence and access and gratitude and these broader conceptions of corruption. And then in the decisions that came after that, and in particular in Citizens United, you had some new members of the court, and you had 5 justices saying, no, we're back to, we think this has all been about quid pro quo corruption all along, and that's the only thing that can be targeted here. And just to give a little more content to what they're saying there, I mean, it's not that they're oblivious to the reality of the effect of money in politics, but in their view, if you once you start going beyond targeting quid pro quo corruption, it's just too difficult to draw a line that doesn't allow the legislature to create rules that are actually designed to keep the legislator who's creating them in office by ensuring, you know, that certain people are going to be able to give them money, that incumbents are going to be able to get more money than challengers, a lot of things like that, and to come up with rules that really are about just whose money and whose speech and whose views you favor. And the First Amendment is supposed to be neutral to all that, and the court says, you know, when you start getting into that territory, we need to err on the side of protecting the First Amendment activity. Then the last piece of McCutcheon that I think is relevant not just to the McCutcheon decision itself, but a little more broadly to the way the current court thinks about these issues, and particularly about First Amendment issues, is this notion that when a government, state or federal, is infringing upon First Amendment activity, the current court takes very seriously the basic principle that the government needs to be the one who explains to the court why that's okay. You know, it's not the challenger's burden to come in and say, hey, I should get to exercise my First Amendment rights. Presumptively, you do get to exercise your First Amendment rights, and the government needs to be able to come up with a pretty good excuse as to why it should be able to prevent you from doing so. And in conjunction with that, the government also needs to be able to show why what it's doing is a narrowly or sufficiently targeted way of addressing that, and isn't just kind of a blunderbuss approach that sweeps in far more protected activity than necessary. So in this case, the court concluded, you know, first it set forth these principles, and then the Chief Justice explained, you know, the nature of this restriction. Not only are we afraid it doesn't, you know, we don't really think this is targeting corruption in the first place, but to the extent it is, it's vastly overbroad, because most of the, you know, the small number of people that want to give above aggregate limits, they're not trying to bribe somebody. They're, you know, and there's millions of restrictions already in place that prevent their money from, you know, being circumventing and finding its way back to one candidate, and all of these elaborate hypotheticals that the dissent posed about money finding its way back just aren't really that realistic. And if that's what Congress is concerned about, they can do much narrower things to target it. Now, I think McCutcheon is, you know, it's part of a string of decisions we've seen from the Roberts Court over the past decade that show that this is a court that, you know, there are 5 members of this court that very strongly believe that campaign finance activity is core First Amendment activity, and I don't think that's going to change anytime soon. I do think this is also part of a broader trend that we've seen on the Roberts Court of the First Amendment really a relatively robust conception of the First Amendment from a number of justices on the court. You have decisions like Snyder versus Phelps upholding the right of some what anybody would pretty much think of as hate speech occurring outside of military funerals. You have a majority, almost unanimous court concluding that restrictions on these horrific videos, crush videos, were a constitutional problem. You have violent video games being a problem. You have a number of these decisions. The Stolen Valor Act decision a couple of years ago saying it's unconstitutional to have a law that prevents somebody from lying about whether they received the Congressional Medal of Honor. Consistently, you're seeing these opinions, and you're consistently seeing a lot of them written by the Chief Justice. And one thing that I find very interesting in just a broader trend here is the strongest disagreement you tend to see in these opinions is Justice Alito is often the dissenter in them. So the two newest conservative members of the court seem to have a pretty different conception here. Justice Alito's much more government-friendly in these First Amendment cases and takes a lot more pragmatic view and just doesn't really share the hardline First Amendment view that a number of his colleagues and in particular the Chief Justice seems to share, to be kind of the leader in a lot of these First Amendment cases that we've seen over the past decade. The other thing I want to talk a little bit about in terms of trends on the Roberts Court is just the role of federalism in general, because I think it's been a huge piece of this court so far, all around the kind of defining moment of the court being the Affordable Care Act challenge and kind of where they were going to go with all of the federalism issues in that. So there's two observations I would make about the court's federalism jurisprudence right now in general. When you think about federalism, there's really two ways to think about it. You could think of these as competing conceptions or complementary conceptions. But one piece of it is really just it's about states' rights, the rights of states as states, and protecting the sovereignty of a state as essentially possessing much of the same sovereignty as the federal government. The other conception of federalism is, yes, that's important, but why are we protecting that? We're protecting that because we believe that by dividing government between the states and the federal government, we're actually protecting individual liberty. And the point here is to prevent either government from having very much power, and by doing so, to ensure that the individual has. It may sound counterintuitive if there's two governments that impose restrictions on you, but in the framers' view, if they're both competing with each other for power, they'll get less done, and there will be fewer restrictions on individuals. And this is the basic premise of our government. And I think to go back to a case that was discussed a bit earlier, because I think it really is just a great illustration of the role of federalism on this court, the Bond versus United States case. There's actually been two decisions in that case, the one that just came down a few weeks ago, and then there was one that came down a few years ago, because the case first got to the court on a question about standing, where the government had actually confessed error, but the government originally argued that this criminal defendant could not challenge the constitutionality of her own criminal conviction on a federalism theory, because the courts had said that only a state can bring a challenge that has to do with federalism. And the court unanimously rejected this notion. But what's important to me in that first Bond decision is it's kind of this ode to federalism in the view of the Roberts Court, and it's written by Justice Kennedy. And if you ever kind of want to just read something that explains to people the basic principles of federalism and how they're supposed to influence our government, he walks through this whole analysis of it's very important for states qua states, but it's just as important to protect individual liberty. And this has been a little bit of, if you look case by case, sometimes it's a case where the court's going to go in the state direction, and sometimes it's a case where they're going to go in the individual liberty direction. The Affordable Care Act is a great example. There were two issues in the case. The individual mandate was in some respects more of an individual liberty case. We know what the outcome was there. The piece of the case about Medicaid was actually much more of a states' rights piece. The only party in that case was the states, and that piece of it succeeded, and succeeded with a remarkably large number of members of the court agreeing that it was an imposition on states' rights. But so I think when you look at the court's federalism cases, it's interesting, and it will be interesting over the next decade to watch and see, and when you're thinking about cases in your own jurisdictions, whether it's a case that kind of fits more into the individual liberty conception or the state conception, and the justices really kind of use both of those pieces a little bit wherever it suits their purposes. And then the one other thing that I would say about the court's jurisprudence and federalism jurisprudence, and I think this is something particular and to the Chief Justice and Justice Scalia that we've seen. You heard some mention earlier of the necessary and proper power. And the necessary and proper power has long been one of the things the government basically relies on whenever the federal government, if it can't explain why they're allowed to be able to do what they're doing, it's necessary and proper. And for a long time, that was pretty much true because everybody focused on what's necessary. And if you go all the way back to McCulloch versus Maryland, you have Chief Justice Marshall saying pretty much anything is necessary. We're not going to get into the business of deciding how necessary something is. Well, what's been very interesting over the past pretty much 2 decades now is this slight resurgence of the notion, yeah, but the clause says necessary and proper has some content. What is that content? And so when we first saw this back in the court's commandeering cases in the 1990s during the Rehnquist court, where you get this little bit of this notion coming from Justice Scalia of, maybe there's not a commandeering clause in the Constitution, but there's a necessary and proper clause, and that means you can't do things that are improper, and this is improper. Well, this all, has itself some grounding in McCulloch versus Maryland because that decision says lots of things are necessary, but then it goes on to also say, but you can't use the necessary and proper power to grant to the federal government any great substantive and independent powers that are bigger than the ones that the Constitution itself grants them. And this language about the great substantive and independent powers has now popped up in a few decisions over the past few years. It popped up in the Chief Justice's opinion in the Affordable Care Act. It popped up in Justice Scalia's concurring opinion in the recent Bond case when he was writing about the scope of the treaty power. And it's this little bit of a trend we're seeing of, people have been giving us a hard time about where do these federalism principles come from. Where do we ground them in the Constitution? What kind? We're supposed to be textualists. Where's the text for this? And we're pretty comfortable with the notion that, well, we don't exactly need text because it's implicit in the entire Constitution that you have this division of powers. But at the same time, that they seem to have it's garnering a little bit more attention and support, this notion of, and by the way, we do have some textual support for this. So I think it'll be interesting to watch over the next 2 decades and see kind of if this kernel of an idea with proper and going back to these ideas all the way from, McCulloch versus Maryland, one of the very first decisions of the Supreme Court, one of the most meaningful decisions, gets this resurgence and becomes a little bit of a house for some of these federalism ideas that we've been seeing in cases like Bond and the Affordable Care Act cases, and I'm sure we'll see many of them over the next few decades. So with that, I will let Elizabeth talk for a bit.
Thank you so much for having me here this morning. It's great to be here with you, and I'm very honored to join you. I've got to say, I spoke about the Supreme Court to the International Municipal Lawyers Association on a Saturday morning early like this, and you guys look in much better shape than that crew, although it might have been because the conference was in New Orleans, and a Friday night in New Orleans can make for a rough Saturday morning. But it's great to be here with you, and I'm pleased to be on the panel with Erin Murphy. We disagree on a lot of cases, and McCutcheon is certainly one of them. I filed a brief on the other side in that case, and for obvious reasons, I think the decision came out incorrectly. And so if you'd like to talk in the Q&A about sort of how in the states, what states can do even after McCutcheon to try to reform the campaign finance system, I'd be delighted to talk about what's going on now and what is being planned in the future. But I would like to talk to you briefly this morning about a case that I hoped to have more to say about this morning. It's the Noel Canning versus National Labor Relations Board case, which is a fascinating constitutional law case about the president's recess appointment power. And I say that I wish that I thought I would have more to say to you about it, because we've been expecting this decision to be handed down sort of every opinion day for the last 2 weeks or so. The case was argued in the January sitting, and there are only 4 cases left from that. And so you never know which cases are coming out when the court hands down its decisions. It just announces it's going to have an opinion day, and then everyone is glued to SCOTUS Blog or waits outside. On my hat as a media legal analyst, I stand out with the cameras and the interns. I don't know if you've seen the running of the intern videos. It's very sad and amusing at the same time when they rush out with the paper copies. You can quickly see what they are. And so everyone was predicting that the recess appointments case would come down, and I thought I'd have a great analysis of the decision for you, but instead all I have is speculation. but I'll start first with actually the facts of the case. So the Constitution gives the president the power to, as the Constitution says, fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. And the whole purpose of the Recess Appointments Clause was to allow the executive, the sole president, which was an innovation in our enduring Constitution from change from the Articles of Confederation, to have someone who would be 24/7 on the job, as opposed to Congress, which would not be sitting continually, would have these breaks in business. And so the president, as sort of the always on the job figure in the government, should have the ability to ensure that we have a properly functioning government. We have, the officers and officials who are going to implement and run the government. This includes military officers, agents, judges. And so the framers put in this recess appointments power. And it's only a temporary appointment that lasts until the expiration of that congressional session. So for the history of our country up until a couple of years ago, this power was understood to allow, since the time of George Washington, to allow the president to appoint officers to vacancies that occurred. And then let me start out by saying it a different way, because the D.C. Circuit Court of Appeals issued a very interesting ruling, which is the ruling that is currently on appeal before the court. And it dealt with 3 appointees to the National Labor Relations Board, which, as you probably know, deals with claims by workers regarding their workplace conditions. That's a very general description. And these appointments were made by President Obama during a recess of the Senate to fill positions that existed before that recess. So it's not like the Senate went into recess, someone died on the NLRB, and then the president appointed someone within that same recess. So they pre-existed the Senate's recess. And the recess that the Senate took was what we call an intra-session recess, as opposed to an inter-session recess. And the D.C. Circuit said that those 2 facts about these recess appointments made them unconstitutional. No court had ever said that before, although no court really, with the exception of one case in the 11th Circuit, no court had really ever grappled with the Recess Appointments Clause, because pretty much settled understanding amongst the branches of government was that this practice of making appointments like President Obama made were constitutional. And in fact, this same type of power was zealously used by the George W. Bush administration, was used by Presidents Clinton and George H.W. Bush, as well as President Reagan, and has been used going back hundreds of years by presidents of both parties. So the D.C. Circuit's ruling was quite remarkable. So no one was really surprised when the Supreme Court actually took this case. But what was added to those arguments made by the D.C. Circuit, and the one that I think the court will actually probably rule upon, but I'll put an asterisk on that and get that back to it in a moment, is this third argument that was made at the Supreme Court, which is that the Senate wasn't really in recess because they said they were in a pro forma recess, which meant they were all gone and they weren't conducting business, and it didn't have the hallmarks of any session of Congress, but they hadn't technically declared themselves in recess. And so because the Senate should be the one who decides whether it is actually in session or not, that fact made President Obama's appointments unconstitutional, not these other two things that the D.C. Circuit had said, which are sort of very novel interpretations of the Constitution. And it seemed at oral argument like this was going to be perhaps what the justices were going to seize on. Even some of the more liberal justices, who a lot of analysts thought might be more sympathetic to the administration's position, even they seem to think that the Senate should be the one who decides when it is in an official recess or just sort of a pro forma recess when they could in fact conduct business. My asterisk to that is that it seemed like there was sort of an agreement amongst the justices that might be the way to go. Now, we, partly because these decisions take so long to come out, we all like to engage in the parlor game of sort of figuring out who's writing it and what they're going to say and what the vote breakdown is going to be. And so a lot of us have thought that if that was going to be the way the court would have gone, we probably would have seen the decision by now. And sort of the longer it takes, the more nervous a lot of us get. But it could mean that there are other opinions being written that do delve into the history and take the view that the D.C. Circuit took, and so that could be why it's taking a long time. But one thing that I would like to emphasize in talking about this case is that it sort of has turned into a partisan issue. People have lumped this case into some of the other cases that say, it's the Roberts Court versus the Obama administration. I think you heard about some of the environmental cases that are also up this term, and people have seen that dynamic there too, although the administration got a huge victory in the EME Homer case involving the Clean Air Act regulations in those cases. But it really shouldn't be a partisan issue, this particular recess appointments case, because as I noted, this power has been vigorously used by presidents of both parties. And in fact, some of the lawyers who are arguing against the administration's appointments in this case were themselves recess appointees by Republican administrations. So there's a little bit of, I wouldn't use the strong word hypocrisy, but someone might use that term. So it has turned into sort of a partisan issue, but it really shouldn't be, in my view. And so speaking of partisan issues, talking about larger trends of the Roberts Court, I think that Erin hit the nail on the head when she talked about sort of the First Amendment and federalism being two major themes of the Roberts Court that make that court particularly interesting. And I think when you look at federalism, you see the Roberts Court as a body that is certainly willing, some might even say eager, to limit the federal government's power. And they do that with respect to the states, as well as with respect to individuals and private entities. And I think, when I look at the Roberts Court and think about the ways that they have limited the federal government's power with respect to the states, I think we see the court certainly using the Voting Rights Act as I think that's one of the most salient cases for me. The court last term in the Shelby County case said that the federal government could not treat southern states that had, mostly southern states that had a history of discrimination in voting, could not treat those states differently than other states based on data that the court said was not up to date. There was a very hearty dissent in that case by Justice Ginsburg saying that no, in fact, the data is not out of date. There is a very long record that was amassed by Congress in support of the extension of the Voting Rights Act that shows that there is a reason that we have a requirement in the Voting Rights Act that these states and localities must pre-clear changes to voting laws, and even more important, while there is this limitation in the Constitution with respect to the federal government and the states and the 10th Amendment, we had amendments after that with respect to the Voting Rights Act, the most important being the 14th Amendment and the 15th Amendment, which guarantee equality and the right to vote free from racial discrimination. And they have enforcement clauses in those constitutional amendments which give Congress the power to enforce those provisions. And so that modifies, and in fact was expressly intended to strengthen the federal government's power vis-a-vis the states when it comes to those issues of equality and anti-discrimination principles. So I think the Voting Rights Act case is an example of the Roberts Court limiting federal government power with respect to the states. And then when you talk about individuals, I think that we've seen, the campaign finance regulations. The court has said that the government does not have a legitimate interest in regulating corruption and big money in politics based on the First Amendment. The Bond case, I think, is another example, and I would just like to disagree a little bit with the characterization of that case in a way that I think is important for this crowd, and I just think in general. It wasn't as if the prosecutors in that case had before them the choice between applying state or local law and the federal law. Actually, Carol Bond's victim went to the local law enforcement, and they did not help her. And so when she finally went to the federal prosecutors could only apply federal law. It's not as if they could choose themselves to take the role of the state prosecutors in that case. So that's why, you can certainly say that perhaps the federal prosecution was maybe not the best use of prosecutorial discretion, but she actually went to the state and local officers first for help, and she did not receive any there. So but Bond, I think, is a very important individual rights when it comes to federalism case for the reasons Erin said. The first iteration of that before the Supreme Court was about whether an individual could press federalism claims on her own behalf. And so I think that's really interesting. And I would just end before we get into discussion, which I'm looking forward to, with the Roberts Court's use of the First Amendment has really been an interesting facet of that court. Some observers have called this sort of the Lochnerization of the First Amendment by the Roberts Court. So the Lochner era refers to this time, the very beginning of the 20th century, when the court, in the aim of economic liberty, struck down various, mostly workplace regulations about child labor, wage and hour restrictions, on this very robust theory of economic liberty that we should have freedom of contract, et cetera. And they did that through the Due Process Clause, this sort of idea of substantive due process, and that's sort of the hallmark of the Lochner era. And some observers have seen this sort of idea revived in the Roberts Court, but using the First Amendment to strike down economic regulation or regulation that affects corporate activity. So we've seen that in the campaign finance context by giving corporations and Citizens United the ability to spend for indirect expenditures. There are interesting First Amendment cases coming up about disclosure laws, which also relate to the states. This can be something about putting warning labels on tobacco products. It can be about other sort of compelled disclosures that corporations would have to make about their activities. One case came up through the Ninth Circuit, I remember, about when you have to talk about where stormwater drains to and whether that was a violation of the First Amendment or not. So that's something I think also to keep in mind about the Roberts Court's First Amendment jurisprudence. But I think that's about all that I wanted to talk about, so we can turn it over to Q&A if you'd like. Thank you so much.
Questions? Please, go ahead, Bobby.
Erin, you mentioned that there was a case, and I'm sorry, it slipped me, where maybe Roberts stepped through and outlined federalism as it applied to the states. Which case was that?
So this was Justice Kennedy's decision in the first Bond case.
Kennedy's decision in the first Bond case.
Yes.
And also your counsel opposite there maybe had argued a little bit that there was a way for states to limit somewhat campaign contributions. Did I hear that right, or is there an opportunity for that to occur? And if so, how do they take that effort?
Yeah, so there's been a lot of effort post-Citizens United and post-McCutcheon of grassroots organizing in the states. Some folks have focused after Citizens United specifically on corporate spending, and so there have been movements to try to change state corporation law to put into charters of incorporation limitations on how corporations can use corporate funds in elections. I think those movements are still working. There haven't really been a lot of a lot of changes yet with respect to corporate law. There have been some efforts with respect to public financing of elections, but even those might run into trouble with the Roberts Court on election law because there was another case about public financing in Arizona, and the court found that that particular public financing scheme was unconstitutional. So it's risky to engage in these efforts in the states because, at least at this point, the Roberts Court doesn't seem to have found the campaign finance regulation that it likes. But people are still trying, and I think that one of the areas of innovation that we're seeing through campaign reformers is with respect to judicial elections. But I think that one thing that is important to me in talking to you guys is that having people who actually know the campaign process and know the way that money works in politics, it's very important to have their voices heard, because I think there was substantial criticism after the McCutcheon ruling came down that sort of it reflected a lack of understanding of how political reality works in campaigns, but there's sort of just a disagreement between people who support the ruling, people who don't, about whether that's true or not. But I think that the more and more that people talk about the way that money actually works, and we've seen some politicians at the federal level talk about their experience in raising money and how they see money in politics working, I think that's only helpful. And to get that from state electeds as well, I think is very important.
One interesting data point for states is a Montana experience shortly after Citizens United. Montana had in place a similar restriction to the one struck down in Citizens United. And the Montana Supreme Court, which is a little bit known for going its own way, basically said, yeah, the federal rule is unconstitutional, but the state one's fine, because Montana just has a different experience with corruption. And a lot of folks, that went up to the Supreme Court, and folks thought maybe this will be, the court will limit this or reconsider or whatever. It ended up being summarily reversed with, just the same dissenters from Citizens United saying, nobody's going to reconsider this, so it's not worth us even taking the time to consider it. I think, that was a law that was almost identical to the one that had been struck down in the federal scheme, but it's a note of caution when thinking about the ways in which to frame state laws to try and get around federal prohibitions that the court has put in place.
Thank you. Please.
So I'm curious on the campaign finance. So if Buckley Vallejo held money as speech, and then the case that just removed the aggregate spending limits, do you think that there'll be some kind of movement to base limits to candidates in the future? I know that's kind of a...
Oh, it's already happening. Yeah,
Has it?
Absolutely. I mean, if you take that view to its sort of, if you take that view under the... So the Roberts Court has done something very interesting with Buckley, I think. So in Buckley, you have the idea that money equals speech in campaigns. And then you add to that the Roberts Court sort of tweak on what the government's interest. So of course, we all know that the government can regulate speech under the First Amendment in some instances. The classic, you can't shout fire in a crowded theater. There are some cases in which speech can be legitimately cabined under the First Amendment. And with respect to campaign money, what the Roberts Court has said is that basically the government's legitimate interest in cabining that speech is only to prevent quid pro quo corruption. And that in my view, is a narrowing of the government's interest, because I see some of the early cases also allowing sort of the appearance of corruption, something that undermines the public's faith in the integrity of the political system. And so I see the Roberts Court as having narrowed that government interest in regulating campaign cash to basically, essentially, sort of handing over a sack of money for a vote, sort of quid pro quo bribery. And Erin might disagree with me on that, I don't know. But, but one thing that I think is really interesting that Professor Marty Lederman has brought up a couple times, he's at Georgetown and has written a lot of great stuff about this, is that if the Roberts Court's description of money in politics in McCutcheon, in which he says that, Chief Justice Roberts says that the fact that you use money to influence your legislator, that's just democracy. That's a way that we participate in democracy in the same way that we vote at the ballot box. That if that is okay, then essentially giving you money for a vote, why is that unconstitutional? You're just being super responsive to me giving you money. So even bribery seems to be kind of suspect under that, and that's sort of a very extreme position there. But it's not crazy under the way that Roberts described money in politics as a sort of healthy, dynamic feature of democracy. I find it troubling, and I sort of would agree with Justice Stevens in his Citizens United dissent that I think we'd all agree that there are a lot of problems with our current system of democracy, but very few people would think that a lack of money in politics was one of them.
Okay, well, Erin, do you want to have a rebuttal?
Sure.
There will be no sir rebuttal.
The Chief Justice's opinion, he was very careful to take no position on the base limits issue and to write an opinion that was very, perfectly consistent with everything the court had ever said to uphold base limits. I mean, on the other hand, I don't think his opinion commits him. A number of the justices are pretty committed to their views on this stuff, and he hasn't had an opportunity to say anything on that, and neither has Justice Alito. And I don't think, I think it's still a totally open question where they would go on base limits. The issue that to me is a little more on the table, and it's already being challenged as well, is the soft money ban that was upheld in McConnell. I do think a lot of the reasoning in McCutcheon is inconsistent with the reasoning under which the soft money ban was upheld. Now, I would say that's because the reasoning that was used to uphold the soft money ban is flatly inconsistent with the reasoning of pretty much every other campaign finance case before and after it. And McCutcheon's really a return to a more limited conception, and that I don't think suggests that bribery is okay. But in all events, I think that the area I'll be interested to watch first is soft money. I think the court will do anything and everything it can to avoid a base limits case for a while, but that's just my own speculation.
Okay. Next question. Well, I have a few. Oh, no, let's go here and then here.
Just curious, on the recess appointment case, can you speculate both ways, and what do you think the ramifications are going to be?
Pardon?
Can you speculate both ways, if it comes down one way or comes down the other way, with the ramifications on the appointees and then also going into the future?
Yeah, so I think that, so I should say I filed a brief in that case in support of the constitutionality of the appointments. I would be shocked if the appointments were held to be constitutional. That just didn't seem to be the way that the court was going to go. Anything can happen in the Supreme Court, but I would be shocked if that's what happens. It's really just a question of how the court is going to write the opinion, I think. But there is an open question about what the ramifications of that will be. With respect to the actual facts of the case and the National Labor Relations Board opinions that could be affected, and that's about a 2-year span, so several hundred decisions that were issued from the board. There could be sort of ways of ratifying those rulings, so they just basically have the same effect that they always have through 2 different doctrines that the Supreme Court has used: the de facto officer doctrine, or the currently properly constituted board could mass ratify these rulings. And so the immediate effect of a ruling saying that those recess appointments were unconstitutional could be very small. But of course, there could be challenges to the use of those doctrines to ratify the earlier decisions, so they could still be mired in litigation. And I would actually expect there to be challenges to the use of those doctrines to try to make those decisions valid. If the court goes with the idea that the Senate, by being in a pro forma recess, even if they've all gone and don't intend to do any business, if the court says that that can prevent the president from making recess appointments, I think that actually does have sort of a functional impact going forward, because it would essentially allow the Senate to, if it wanted to, thwart the president's ability to make recess appointments by just deeming a recess to be just a pro forma recess and not a real recess. And so that sort of gives the Senate the power to tell the president when he can and cannot, or she can or cannot make recess appointees. And I think that that sort of messes with the balance of power struck by the framers in the original Constitution. So that is sort of the interesting part going forward. I think probably the NLRB rulings will be somehow verified.
Can I just exercise my right to give a very quick rebuttal, since I've argued in another case that the recess appointments are unconstitutional? The one minor detail but important one that wasn't quite played up in Elizabeth's presentation is the President Obama's decision to make a recess appointment during a pro forma session was unprecedented. It had never been done before, and many of the politicians and lawyers that are arguing that it's constitutional, the reason it wasn't done, they were the ones saying it was unconstitutional in the past Republican administrations. So if
not all of them.
If all the court holds is that that an appointment during a pro forma session is unconstitutional, I don't think that's going to have a tremendous impact, because they really haven't ever been doing them. If the court actually says something broader, such as you can't have intra-session recess appointments, you can't have appointments unless the vacancy occurred during a recess, that all could have more of an impact. But at the end of the day, the real game changer is just the way our government functions. Back in the late 1700s, Congress wasn't there when they recessed, and the Senate, they would have to travel across the country to come back. Nowadays, if the Senate wants to be in session every single day of the year, that's its prerogative. It's perfectly capable of doing so. So, regardless of what the court says, the Senate just possesses the ability to frustrate the president's ability to ever exercise the recess appointment power at all, and may just continue to kind of do that, which is what we've been, that's what led to this case happening in the first place.
Okay. Back here.
As a former Roberts clerk, I was just interested in your perspective on the Affordable Care Act decision, and most of us weren't really buying what Roberts was selling there. So.
Before you answer that, let me just add on to that, because we are almost out of time. We did start a little bit late. I went to law school in the 70s, and back then, frankly, we could see no end to the Commerce Clause. And before NFIB v. Sebelius, I still didn't see an end to the Commerce Clause. Well, now I know there's an end. I don't know where the end is short of that. In addition to the question that has been asked, do you see cases currently percolating their way through the court system, that the effect of which might be that the court would espouse a legal test or standard by which we might be able to discover where the end of the Commerce Clause is? We get no help in the Sebelius decision.
Yeah, well, that may be a little wishful thinking that they're ever going to tell us where a real end is, but well, so I certainly have views about the decisions. I actually represented the states in the case, so disappointed with some aspects of the outcome. On the other hand, you do get some really wonderful principles from the opinion. The majority of the court and the Chief Justice did hold that the individual mandate violated the Commerce Clause, and we do see a principle there of you can't compel people into commerce. You see, as I just mentioned earlier, the notion of, and you can't use the necessary and proper power to get around what the Commerce Clause prevents you from doing. So I like to focus on the positives of the opinion, in my view, which, where let's just pretend that tax power piece didn't exist. I'm sure others, would be happy to pretend that commerce power piece didn't exist. But to me, yes, the bottom line is what most people were interested in. But as somebody who practices before the court, I actually think the opinion has tremendous value going forward for purposes of understanding how the court thinks about these things. And you have 5 justices who at the end of the day said, you know, we think there's limits on federal power. We think there's limits on the commerce power. We think there's limits on necessary and proper. We think there's limits on the spending power. These are those are like the 3 pillars through which the federal government manages to just create the power to do anything it wants. So even the notion that the court believes there are limits on those 3 powers is tremendously important, and hopefully over time we'll see some development of the contours of those limits. And one area that I think could be interesting, there's been a number of cases out there about the federal hate crimes statute, which is legislation that involves both the Reconstruction Amendments and the commerce power. There's a number of Court of Appeals decisions on this, so at some point I think there could be a split, and this could be an issue that finds its way to the court. And some of it will involve the federalism issues that we saw in decisions like Shelby County about the scope of Congress's power under the Reconstruction Amendments to impose limits on how states can govern. But there's also a Commerce Clause strain to all of this. In some of these cases, the way the government asserts the power to bring hate crimes prosecutions is by saying things like, oh, the weapon you used to commit this hate crime traveled in interstate commerce, and therefore it's a federal interest. And so I think that line of cases to me is one of the ones that has the most potential in the next few years to maybe find its way to the court and get some of these issues before them again. I'm not tremendously hopeful that any of these decisions will ever produce anything like a clear line or readily applicable test or anything like that, but knowing that they believe there are limits is valuable in and of itself.
Thank you. Thanks to the 4 of you, to Erin and Elizabeth and Marcus and Lisa. We're glad to have you here. Please join me in thanking them this morning.